I came to talk about the Hennifer case, which was a wrongful death case of a 15-year-old boy. But I have a couple of comments after listening to David speak that I have to make a confession. Number one, that David is one of my all-time heroes. The work that he takes on and the clients that he represents are the most difficult cases there are. And he's not unlike a lot of the criminal defense lawyers here. They represent people who society typically rejects or don't like, the terrorists, whatever. So representing people like that is amazing to me. The fact that you can be passionate about it and represent the people who are the least powerful people in the world. So anyway, I wanted to make that comment. Sorry. I had too much partying last night, and so my voice is a little bit cracking. But the other comment I wanted to make, or the other confession I wanted to make, is I wanted to come and speak about the Hennifer case and act as though I were solely responsible for the result and that I had no help at all. I shamelessly wanted to market myself as the solely responsible for that result. But the truth is that I'm part of the best law firm in the state of Idaho, and that is the ITLA organization. And I got a lot of help from other lawyers and friends of mine before I went into the courtroom. I talked to, well, my brother provided me a tremendous amount of assistance and advice, provided me a closing argument from a Seattle attorney who, and I can't remember his name, I'm sorry, but had represented a brain damaged baby in a an injury case in Haley, and had made the most eloquent and persuasive final argument I've ever read. And of course, having that resource was invaluable to me. I stole a bunch of his ideas and used them to my advantage. And then that's true. I talked to a number of lawyers. I'm sure I talked to Kurt Holzer. I talked to, and I used an attorney named Kevin Donahoe. I don't think Kevin's here today, but he's an excellent attorney up in Haley. This lawsuit was tried in Haley, and I actually used him to help me pick the jury, and he knew a lot of the jurors and gave his time to help me pick a jury, spent a day picking the jury. He came and watched some of the trial. He was there for the final argument, and after doing my initial final argument and the defense had given their argument, we took a little break, went out in the hallway with Kevin. Kevin gave me some great ideas on rebuttal, which I used, by the way. Not all of my rebuttal was his idea, of course, but I've had that kind of assistance throughout my career, and I know I'm not the only one that gets help from other attorneys in the state, and it's a wonderful resource. So I wish I could take credit for the result, but there's a lot of credit to go around. I talked to Ken Pedersen and Brian Hilverda. Brian was at the final argument, as I recall, and gave me some ideas. So thank you. And I really want to express my appreciation. Representing a wrongfully killed 15-year-old is not a hard client to represent, frankly. I mean, the going in front of the jury, it's a friendly jury that you're going to pick. You already have compassion. You already have them on your side. So it's not like representing a terrorist. I want to provide some assistance, so rather than rely on my speaking skills, which are sometimes poor, I prepared a top 10 list, kind of off of the David Letterman top 10 lessons that I learned. So I'll just hand these out. And I also uploaded, Quinn uploaded I had two appellate briefs that were uploaded to the ITLA website. It's not that I'm the greatest writer in the world, but I think there was a lot of issues raised that if you are writing an appeal brief or a trial brief, that some of the issues that were raised were pretty helpful. So let me tell you just the basic facts of Hennifer. Austin Hennifer was a 15-year-old child. He was in a driver's training class, and it was the first snowfall in October of 2010. And the class started out at, I believe it was 7 in the morning, and it had just snowed. The roads were extremely icy. The time of day, of course, was just before sunup. He and another student named Jennifer Maris, which Brian Hilverda represented, and the instructor got in the car. They drove west towards Boise on Highway 20, and after driving a half hour, the instructor asked Austin to conduct a 3-point turn on Highway 20. And so he was in the process of turning around and was perpendicular in the road when another car driven by Sergio Lopez Rodriguez, driving 50 miles an hour on the icy roads, came upon them, couldn't see them immediately because they were sideways in the road, T-boned them, and of course killed Austin, seriously injured Jennifer, and the driver's training instructor, Mr. Meekum, was also pretty seriously injured. So the top lessons that we learned from that case, the most obvious thing, and I think from just a academic perspective, is the big issue on appeal was whether the jury had been properly instructed on reckless. And it's kind of mystifying to me that was a big issue, because there was a ton of case law out there talking about the objective standard of recklessness. Holzer's case in Phillips versus Earhart talked about, in fact, I used the same IGE jury instruction that you used, Kurt, and then there was the Guy Hallam's case, the Carrillo case, where there was an objective discussion of the objective nature of that proof. But that became the issue, the legal issue that was contested all the way through. I think they argued summary judgment, motion in limine, motion to dismiss, 3 motions during trial after my case in chief, trying to get the recklessness thrown out. And the Judge Elgee, of course, continually relying on existing case law, upheld the objective standard. And so I guess the one thing that is now clear, because it was directly addressed, is the objective standard rather than the subjective recklessness standard, which if you look at the Idaho Tort Claims Act, if there's an immunity issue, they have a definition of reckless in the immunity part of the statute, where it is a subjective standard. Their definition is that the defendant must subjectively recognize the danger and then act in disregard of that danger. So if you have a tort claim case, you might still have to deal with that subjective standard. The lesson number 2, or number 9, I guess, from the top of the page, one of the things that surprised me after trial, I talked to the jury foreman to ask them how they arrived at their decision. It was interesting. The jury literally took, I think, 60 minutes to make a decision and come back with a $3.5 million verdict in which they found the driver's instructor was reckless. But the thing that I'd always thought that proving reckless was a lot easier to prove than a willful violation. And the jury foreman told me that they debated a long time, he said, which I thought, okay, you're only out for an hour, buddy, but I don't know what a long time is. But he said they had the most difficulty with understanding what the word reckless meant. And so they kept reading the instruction with the word reckless in it, and they kept arguing over what reckless meant. And then they said, well, we just left reckless out, and we read it with willful. And we decided that he willfully was negligent. and not in an intentional sense, but the decisions that he made were clearly conscious in the directions that he gave to the student, the fact that he had disregarded his own teaching, the fact that he had disregarded his own drive right teacher's manual where they teach the kids how to drive. So they didn't have any trouble getting to the point that it was a willful violation, which you have to prove, of course, to get over the non-economic damage cap. So when I argued to the jury, I was arguing reckless. That's about the only thing I argued. I mean, I'm sure I mentioned the word willful, but I really focused on reckless. In the future, I won't do that. I'll focus on willful and emphasize the conscious decisions that were made by the defendant. You know, driving too fast, driving in excess of the speed limit, that's a willful decision. That's a choice. That's not a inadvertent mistake like inattentive driving or something. So you really want to, in order to prove the reckless standard, you want to focus on the conscious decision making. Out of these 10 rules, there's about 3 that I really want to focus on. And the third one, it pays to be adaptable. And Darwin is one of my heroes. And I think he wrote this quote thinking about me. It's not the strongest of the species that survive, nor the most intelligent, but the one most responsive to change. And I am here to tell you, I am not the strongest, and I am not the most intelligent. Someone else in this room is the most intelligent, and I know Dave Comstock's stronger than I am. But I am responsive to change. There is no question. My wife says that I'm fickle, but I'm very, very, I think of it as an attribute. But when I started this case, there were a number of things, and I think you have to be flexible when you try cases. And I think trial lawyers, to be effective, have to be flexible. You have to think on your feet. You have to be ready to change at any time. And one of the things that was interesting about this case, not long after I got the case, there was an article in the newspaper about the lawsuit being filed. And not more than a couple of days after the newspaper article appeared, I get a phone call from a driver's instructor named Debbie Cottonware, who actually took over this class after the accident. And she volunteered to assist me in proving that the school was negligent, even though she was hired by the school to help teach the class. And I thought, wow, this is a gold mine. And I didn't even have to go look for her. She called me. And one of the things that she was really fired up about is that the driver's instructor that caused the accident had just gotten his teaching certificate as a driver's instructor, and he was taught online. And instead of taking a class where you have students in the class and the teacher present and you have an interactive process, it was an online class. And part of the reason that they have this online driver's training instruction is that there's a shortage of driver's training teachers. And it's hard for people to travel from Coeur d'Alene to Boise to take the instructor class. So they made it easier to attend the class, and you do it online at your computer from your home. And her pitch, which I liked, by the way, was that they didn't train him well. He had a horrible education, and that's why this accident happened. Anybody should have known you don't do a 3-point turn on a high-speed highway in horrible conditions. And so I'm thinking, God, that's awesome. I kind of don't like the online education anyway. It's a cheap alternative to having live instructors and live classrooms. That's a fun pitch. Let's do that. I think that'll have some political reception. And so that's where we started out, and I disclosed her and disclosed what her testimony was likely to be. And it was really interesting. We did a few depositions, and her deposition was taken, and right after her deposition was taken, the school district hired the guy that taught the online class. They disclosed him as their expert witness to prove that he was well educated. And it was, they weren't negligent in hiring this guy. He was totally competent and knew what he was doing. And, that allegation that this online class was what caused the accident is total BS. And so I'll never forget about, my client, Dennis Hennifer, went with me to all the depositions. He was a wonderful guy. And we'd gone down to Salt Lake to take the deposition of the defense expert reconstruction witness. And we were talking as we were driving back, which I love with my clients. Love to have them in the car with me when I have their undivided attention and we can talk about the case and talk about them and get to know each other. So anyway, we're talking, and kind of how it works. You start talking. They've hired this Brian Johns, and they're going to have him testify about what a great education Jeff Meekum had, and they're trying to counteract our claims of negligence. And it's like let's go with that. I want to prove that he knew exactly what he was doing. I want to prove that he's willfully disregarding what he knew he was supposed to do. And I'm thinking, Dennis and I got giddy talking about his deposition. And so I immediately disclosed him, learning from one of the Comstock's case, if you're going to use the other side's expert, you have to disclose them as an expert for you or as a witness for you. There's some case law about that. So I disclosed him as a witness for us. Went and took his deposition. He was the nicest guy in the world. He was a passionate educator. He was very competent. He knew exactly what he was doing. And all of a sudden, I had my willful expert. And he was their expert. So, and it was kind of funny. I don't think the defense really picked up on what was happening. I don't think they understood it at trial. But I called him in my case in chief as a fact witness. And like I said, in my final argument, I was nothing but complimentary about Brian Johns. He was the type of educator I expected all educators to be. He was passionate, he was knowledgeable, he knew the material, and he was a great educator. And that guy, pointing at the defendant, he was well educated. He didn't do his job. He knew what he was supposed to do, and he didn't do it. And you can't blame Brian Johns. And obviously the jury ate that up. But if you're not flexible and you get tied into your theory, then you don't come up with that stuff. So you've got to think outside the box a little bit. The other thing about being adaptable, I did talk to a bunch of lawyers before I went up to this trial about what he asked for. It's a wrongful death of a 15-year-old boy. We have no economic damages. I made the decision not to try to prove any economic damages because the thought of that the kids would somehow support their parents, that's outside my experience. My father supported me quite well, and I expect to support my kids. I'm not going to try to prove economic damages. I'm going to just prove the non-economic. And so how much do you ask for the death of a 15-year-old boy? And in every case is going to be different, obviously, because the relationship between the parents and the child is different. And they're good parents and they're bad parents, and it's all over the board. And I had awesome parents and an awesome kid, and so I wanted to ask for a lot of money, and I'd kind of decided to ask for $1.5 million. And we fortunately had a $5 million insurance policy. And so after talking to a bunch of lawyers, I was going to ask for $1.5 million, which I thought was a lot of money. They'd offered the non-economic damage cap. They'd offered $630,000 or whatever it was, $300 for each parent. And it became apparent that, we weren't going to settle unless they admitted my client, Austin, was not negligent. That was Dennis's direction to me: is if they don't admit that he's not negligent, we're going to trial. I don't care how much money they offer. It wasn't about the money. And so, okay, they won't admit it. We're going to trial. Anyway, at trial, you know how trials go. It's a roller coaster. You have good days, you have bad days. When I figured that I needed to ask for $1.5 million, I figured we'd have a couple of bad days. Well, we didn't have a bad day. They had basically 4 defenses. Their first defense was that he was performing a U-turn instead of a three-point turn, and the reason they wanted to pitch that was because it only takes like 3 seconds to do a U-turn. It takes like 30 seconds to do a three-point turn, so a U-turn is less hazardous than a three-point turn, and there's absolutely no support for that. They also were pointing the finger at Mr. Lopez. It's his fault. If he wouldn't have been driving 50 miles per hour on an icy road, this would never have happened. And so they obviously were relying on the fact they're a school and a tax-paying entity, and there's got to be some sympathy for that. And they also their best witness, and as I looking in 2020 hindsight, their biggest defense was the principal of the school was a super nice guy, Mr. Peck, who's the principal in Cary. Nicest guy you'll ever meet. His son and Austin were close friends, and they were going to put Mr. Peck up. They did put Mr. Peck on Friday afternoon. The last witness on a Friday, they put Mr. Peck on the witness stand. And he had nothing of substance to say other than I hired Mr. Meekum. Mr. Meekum's a good guy. He's very well qualified. And then talk a lot about Austin and what a close relationship he had with Austin and what their families had with Austin. And basically they just wanted to say, here's a really nice guy. Don't get mad at us. And they put him on a Friday afternoon, the last witness. And I have to admit, I had no plan for him. I mean, what do you do? And I let me tie in one of my other rules, the rule number 5, wear the white hat. I sometimes have a problem with that. My basic nature, some people that are just naturally nice people, I am very reactive and I'm very aggressive, and I don't want to be. I'm reactive. I can't help it. And I get in people's shit. And sometimes that is not the right thing to do, clearly, because you're taking the white hat off and you're putting the black hat on, and it's not very effective. And so this whole trial, I was just trying to be the white hat guy, and I was trying to be nice. And here's this Mr. Peck, and I'm thinking, I don't think I can out-nice him. He's just nicer than I am. So I contemplated not even asking him any questions because he didn't really have anything substantive to say, but I had no answer to him. But as it might happen, being totally incompetent principal, he talked for an hour and he was really, really nice. But one of the things that he did during his testimony is he talked about a play that Austin was going to be in December. He died in October. He was practicing for the play, and he got his plays mixed up. The school would put a play on in December and another one in the spring. And he got his plays mixed up, and he said that Austin was going to be in this play where they had a driver's training accident and there was a death. Well, kind of a dumb mistake, because Austin obviously wasn't going to be in a play before he died about what happened to him. This was something that the school did in the spring. And they hadn't told Mary Ann Hennifer, who was an aide at the school, that they were doing this play about the car wreck. She shows up at the play in the spring, and it's a play about this death, and there were sirens, and there were screeching tire marks, and there's a death in a driver's training accident. Well, her son had died 5 months before. They had given her no warning. It was incredibly upsetting to her, and she charged out of, once she realized what was going on during the play, she charged out. Mr. Peck had his facts mixed up. And I knew it, because I'd spent a lot of time with my clients. We became very, very close. I'd been at their home a number of times. I knew how upset Mary Ann had been about this, and they handed it to me. The nicest guy in the world was Mr. Sympathy, their big plan, and he totally screwed it up. He was so incompetent, and he was talking about this, and so I got to be really, really nice and say, now, are you sure you're talking about the play that Austin was in? and he got confused and he got rattled, and I was just very nice, but I took him through, didn't you understand that that was extremely upsetting to Mary Ann Hennifer? You knew that, you know, get to go with that. And so he's the last witness. After I asked questions, they asked him nothing because he looked like an ass. And so we have all weekend where the jury is sitting at home thinking about, oh my gosh, how incompetent is the school? That's embarrassing. It's offensive. Instead of having they're such nice people, it was, oh my God, they're incompetent. So where I was going with this, and I digress, but you have to be flexible. So after that day, I thought, oh my God, this is going to be a big verdict. And the question is how much do you ask for? And you know, I didn't have a bad day. Every day went well. They never made a point, in my opinion. I mean, they never captured the jury. They blamed Austin, but they never ever had anybody directly address why Austin was negligent. And so, anyway, you have to be flexible. Once I realized how bad their defense was, I asked for $5 million and I got $3.5 million. So I had no intention of ever asking for that much money, but the insurance policy limits were $5 million, and so what the heck, right? And it seemed to work. Yeah.
What did your jury say about that $5 million reward? I mean, was there any jaws dropped, or we're talking before and later? About asking.
Like I said, they spent an hour, and this is kind of interesting too. We had a guy, the jury foreman was a former attorney, and one of the things I was going to talk about is I don't think every jury in the state's going to award $3.5 million for the wrongful death of a 15-year-old. I just don't. But we happen to have a really, really smart jury in Blaine County, which you tend to get up there. I mean, highly educated people. I had an engineer. I had this attorney who's now a realtor who during jury selection, we were trying to figure out if he could stay for the entire trial. We figured it was a 2-week trial, and he was a little concerned because he intended to go to a shareholders meeting at Berkshire Hathaway in San Francisco. And Judge Elgee, we took him into chambers, and Judge Elgee was asking him, so, you know, how important is it that you go to this shareholders meeting? And he says, well, you know, it's pretty important to me. I've always wanted to do it, and, you know, I'd like to go. Well, Elgee goes, well, are you a major stockholder? Do you just have a couple hundred shares? He says, well, I have 15,000 shares of Berkshire Hathaway stock. I don't know if you're familiar with Berkshire Hathaway stock, but it's like $2,000 a share. So I'm going, yeah, we've got a money guy here. I like guys that think big numbers. And we kept him on the jury, and luckily Don Farley didn't kick him off. He was a diehard Republican. Donahoe and I just debated whether to keep him. Donahoe wanted to kick him off, and I'm thinking, no, I like him. During jury selection, he had made some comment about, you know, if I'd asked them all during jury selection, would you award a significant amount of money? I didn't ever put a number on it, which I'm glad I didn't. But would you award a significant amount of money? And he was the one that said, you know, if I lost one of my kids, yeah, I'd award a significant amount of money. So, you know, I asked for $5 million, and Farley about choked. Oh, that's a significant amount of money. I thought $500,000 was significant. It kind of ticked the jury off when he said $500,000 for the loss of a child was a significant amount of money. But yeah.
One share of Berkshire Hathaway stock today is down a little. It's only $198,545.
Okay, I was off by a huge amount. This guy was, I mean, he was the real deal. And you know, you're not going to get somebody like that in Jerome very often. I mean, you might get one of the dairy guys, but I mean, Blaine County, you have that potential to find some people who are not offended by big numbers, and their definition of big number is a whole lot different than my definition of big number. And I'm sure $3.5 million wasn't a big number to this guy. So, anyway, one of the other things that I did that I think was helpful in the end was number 6, settling with some defendants. One of the things I did, I knew the school district's main defense was pointing the finger at this Hispanic guy who couldn't speak English, Sergio Lopez Rodriguez, and he was driving 50 miles an hour, which I think it's fair to argue that he was negligent for driving 50 miles an hour on icy roads when you can't see. They were pointing the finger at him. They were pointing the finger at Austin. And prior to trial, I made the decision, which I normally wouldn't do under those circumstances, but I made the decision to settle with Lopez. And I honestly believed at the time that would help focus my case only on, I didn't want to argue that Lopez was negligent. I think he was an innocent victim. I think if they hadn't done a 3-point turn, that accident would have never happened. There was no proximate cause. He might have been negligent driving 50, but I didn't see any proximate cause because you don't anticipate somebody doing a 3-point turn on an icy highway at night when you can't see. So I chose to settle with him. It's interesting, they paid the $25,000 policy limit. The underinsured carrier paid, I think, $50,000 or $60,000 prior to trial. And then that allowed, we got some money. We knew, we were going to recover something. And then at trial, I was able to only talk about the school district and the conscious and willfulness of their negligence, unlike Mr. Lopez, that was clearly, if he was negligent, it was simple negligence. It wasn't willful, it wasn't outrageous. And by really focusing in on the school district, I think that was a real helpful. Now, normally I don't think you're going to want to settle. I say generally, I don't think you want to settle out separately, but I think in certain circumstances there are exceptions, and I think this was one of the exceptions. There was turned out to be an advantage. The other thing is Kent Hawkins. I don't know if any of you know Kent Hawkins. He's an attorney in Eastern Idaho, works for Maryland Merrill. One of the best defense lawyers I've ever worked with, by the way. He is one of those really, really nice guys, and he's also really, really smart. And I wanted him on my side. He and I contrasted each other quite well. I'm aggressive, I'm in your face. He's smart, he's nice, he knows when to shut up. And he only talks when he has something really, really smart to say. He only asked maybe 5 questions during the entire trial, and they were all brilliant. And they, he did a heck of a job defending Lopez, and clearly he was able to prove that he was not liable in any way. So, I wanted him on my side. Yeah.
If I'm confused, if you settled with him, how come?
Why was he there?
Yeah.
That was our deal. I said, right before trial, I convinced my clients. My clients were hesitant, but I convinced them that it was the best thing to do. And so, like 3 or 4 days before trial, they'd been trying to pay the $25,000 policy limit. So 3 or 4 days before trial, I said, we'll take it on the condition that you show up and you defend. And they said, great. We have no exposure. Hawkins was there. It's not like we went out and conferred and talked strategy. We never conferred at all. But he was there, and I liked him a lot. I knew he'd do a good job, and he was brilliant.
So did LG know that you had settled?
Yeah, we disclosed it.
And he allowed them, and he allowed the jury to...
It's interesting. Farley didn't bring it out. It kind of cuts both ways. If Farley had wanted to tell the jury, he could have, that we had settled, and that would explain why Kent and I were so cozy with each other. Or that we settled, and it shows that, we don't think he did anything wrong. So Farley, and I didn't bring it out, and Farley didn't bring it out. And as it turned out, I think it was a good call.
So Jeff, your plan, if Farley would have brought it out, would have been just to say, yeah, $25,000.
Well, no, I wasn't going to talk about the money. I was just going to. I sincerely believed, and I sincerely argued that he didn't cause the accident. You can, and I told him, you can find that he was driving too fast. And a reasonable juror could conclude that that's negligent, but who expects a car to be sideways in the road? If they hadn't been sideways in the road, crash never occurs. He wasn't the proximate cause, and obviously the jury found he wasn't even negligent.
They gave 0%.
And yeah, and I made a big pitch. Sergio Lopez is a victim in this case too. This had to be horribly traumatic for him to be involved in a crash where a 15-year-old died and another 15-year-old was seriously injured. And you know, coming from me, I think it has a little more weight than it coming from Kent Hawkins, because you know I represent the Hennefers, and so when I'm saying it, I think it has a little more push. You know, I'm not saying it out of self-interest, even though I was.
So Jeff, did you name Sergio in your original?
I did. Yeah, I sued him. Now, you know, I knew they were going to point the finger at him, so usually, the general rule is you don't let them out. But like I said, if you want to prove reckless, then I think there's, and it's a legitimate argument that he's not liable, then I think there's, you need to consider letting him out. Because it focuses your attention on the real bad guy and how bad they acted. The willful end of it. So, anyway, that was another thing. I think you have to be flexible. You have to make these decisions. There's general rules are meant to be broken, and you have to be flexible. And damn Darwin comes back into play on something like that, in my opinion. I want to talk a little bit about exhibits. I am not a tech guy. I've tried to use tech. I'm not smooth, so I just don't do it. So I have poster boards, and I like poster boards on the really. And I had some Elmo. I used the Elmo a little bit, but I was so rough and unsmooth that it kind of detracts from my presentation. So I like old school. And I contrast that. Jim Thompson was helping Farley at trial. Jim Thompson was really good with the computer and the video exhibits, and I thought he was really effective. Don had a hard time finding his exhibits, and half the time I was finding his exhibits for him and handing them to him to help him move it along. And I think that hurt him, that he was not very smooth. So, and the other thing about old school exhibits, I had these big poster boards with the rules from the Drive Right manual. One, 3-point turn is the most hazardous turn, only use it in rare circumstances, only do a 3-point turn on a deserted highway not highway, deserted rural road, not a highway, never use a 3-point turn on a high-speed highway. I had all of those quotes on poster boards, and every witness that I could use them, it's right there, it's fast, you put it down, the jury's looking at it the whole trial. I mean, my main points were on poster boards. The other, yeah.
What was your evidence that it was a 3-point turn?
It became unanimous. The girl that was injured, Jennifer Maris, testified, right after the injury, she told the police officer that they were in the process of doing a 3-point turn, that Mr. Meekum had told him to stop, do a 3-point turn, and then we'll switch drivers. So we had her testimony, and then all of the accident reconstructionists and the police officer all concluded that it was a 3-point turn, but they kept trying to say it was a U-turn. During the trial, they kept making inferences, even in the appeal, they made inferences that it was a U-turn. And their initial appellate brief said that they were doing a U-turn, which I don't know why they did that. But it was a gift, in my opinion. But even in trial, Farley asked Meekum, Meekum claimed that he didn't have any memory from the accident. And Farley said, well, now that you've heard all the evidence, isn't it true that you were doing a 3-point turn? And he says, yeah. So they admitted it at trial, but still tried to argue that it was a U-turn, which was, like I said, thank you. How do you predict something like that's going to happen?
How does Meekum come across, and how did he handle this whole thing all the way up to trial? Was he antagonistic, defensive?
Glad you asked that. When I took his deposition, God, I don't know how to, I Unleashed the Kraken. You know, that commercial about the golfers where the big beast comes out and is grabbing golfers. I mean, I was after him. I unleashed the Kraken on him, which was inappropriate. But he had that expectation of me at trial, and I had absolutely, I mean, I was on my very best behavior at trial. He was so ready to fight with me at trial that he did a terrible job. They worked on him for a couple of weeks, from what I understood. I mean, they trained him and trained him and trained him, and he just came across as angry and like he was a victim and kind of sulking about it. I mean, he was a terrible witness. But I think part of that was he was on the fight, you know, from the get-go. He was on the fight. And, you know, we didn't have to fight. We just let him talk. And he didn't come across well, clearly. Sometimes less is more. I think the best example I've seen of sometimes less is more is Carly Fiorina during the debate when she answered the question about Donald Trump making fun of her or making fun of women. And she said something very simple like, I think all the women heard what you had to say, Mr. Trump. And that's all she said. And it was so effective, in my opinion. I'm not a big Carly fan, but I thought that was brilliant on her part. And I think that's something that sometimes less is more is something that we need to do. One of what I thought was a problem, the Hennefers had 7 kids. And Austin was the baby of the family. And, you know, maybe I'm just overly concerned, but I'm thinking, okay, yeah, you got 6 more, you know. I know that's kind of harsh, but that did concern me. So when I damaged witnesses, I had Mr. Hennefer was my first witness, and he talked more about liability than anything else, and then he talked at the end about his relationship with his son. One of the things that he came up with that was brilliant, he's a good LDS man, just the nicest man you'll ever meet, and good LDS family, very family-oriented. And he was always struggling with whether he should be filing this lawsuit, because the lawsuit's not going to bring his boy back. And he was always trying to figure out why he was so motivated to file this and prove Austin was not negligent. And then it occurred to him a couple of weeks before trial, he had a plaque on his wall that said the father's, you know, this is Mormon doctrine, the father's role in life is to provide and defend the family. So that's what we talked about. At the end of the trial, you know, why are you doing this, Dennis? You know, this isn't going to bring Austin back. And he said, well, in my faith, my job for my family is to provide for them and defend them. And they're saying that Austin was negligent. And I don't think he was negligent. I think a jury will find that he was not negligent, and it's my duty to protect him. And they're still attacking him. And so that's why we're here. And I thought it was amazing. And it was true. It was heartfelt. And then I had Mary Ann testify. It was the only other damage witness I had was Mary Ann Hennefer. And it was the most heartfelt and compelling testimony I've ever seen. Everybody in the courtroom was crying, and the court reporters were crying, the jurors were all crying, the judge was, you know, trying to hide his eyes because he was crying. But in wrongful death cases, my dad had a trick, and not a trick, but what he would always do in wrongful death cases was the last question he would ask is, what do you most miss about your relative, your mom, your dad, your child, whatever? And I hadn't prepared Mary Ann for that question. And because it's better if it's spontaneous. And, I'd spent, a lot of time with her, preparing her for most of her testimony, and we probably talked about things like that. But the night before, I went to their house in Cary, and we sat around the kitchen table and prepared her testimony. And I didn't ask her that question. So I asked it at trial, and she said, the thing I miss most is going into his room and seeing his bed And for a long time after the accident, I could smell him, and I really missed the smell. You know, I tear up now. I mean, because it was just so true. And who can't relate to that? Your kids do have a unique smell. And if you you know, seriously, it was a complete sensory testimony. She talked about, you know, how we felt, how we smelled, how we talked, his personality, his sense of humor. I mean, it was incredible. And you don't get big verdicts without having fantastic clients. And when I first met them, I'd known a little bit about them before this happened, because my wife's family is from Cary. And so I knew who they were, and I knew what kind of people they were. And this sounds bad, but I was so excited when they came into my office after the accident, of course. As an attorney, that's what we do. But I knew that they were special people, and that all I had to do was ask the questions, and they'd just be themselves. And they were amazing. And obviously, the jury loved them. Yeah, Ken?
Jeff, do you think we should be using reckless more often than we do?
I think you should. I allege it in every case now, and because it allows you to. I mean, I can't remember who had this idea. It wasn't mine. I stole it, like I steal a lot of ideas. But a lot of times the defendants are admitting liability, admitting negligence, and so you don't really get to talk about liability much. And so if you allege reckless, then you get to talk about liability to see whether it's reckless or not. And I think that's a huge advantage, especially in a clear liability case. I considered this a clear liability case. I need to talk about Joellen Gill. Yeah, so I think we do need to allege it in every case, and then answer your question. Always have a great rebuttal. If you can get the last word, you want the last word, obviously. Joellen Gill is a fantastic expert witness. And the issue in this case, in my opinion, is a student negligent for following the direction of his instructor? I mean, Austin was driving the car. That's usually that's a bad fact. He's driving the car. We had testimony that he was only doing what he was told to do. But we also had evidence that he had the instructional material. He should have known that you shouldn't do a three-point turn on a high-speed highway, on a highway at all. He knew, and he was taught, that that was the most hazardous turnaround maneuver. So why didn't he say, no, Jeff, that's really dangerous. We can't do that. I mean, that's a concern. That was a concern to me. So I hired Joellen as a rebuttal expert. And I don't know if you know Joellen, but she has psychology background and she's engineering background. And so she addressed two issues on rebuttal, and she was awesome. She explained Lopez's testimony. Lopez, right after the accident, told the investigating police officer, the first one on the scene who spoke Spanish, that he thought he saw a car and it pulled out in front of him. He thought it was coming out of a driveway and it just pulled out in front of him, and that's what he thought happened. And all of the evidence was that there was no driveway there, number one. Number two, they stopped on the side of the road, and then they pulled over, backed up, and were in the stage 3 of the three-point turn when the accident happened. So we had to explain why he thought that car was off the road. He thought the car was clear off at the side of the road, and he was over here, and they're over here, and all of a sudden they were in front of him. Well, Joellen goes out. Joellen and I went out there with two cars and parked one in the road in a perpendicular fashion just on the side of the road, and then we got in another car and drove up, had the headlights on, by the way, and we got in another car and drove through, and that's exactly what it looked like. The road curved, and so you're going straight down and you're aiming your car straight down, and so it looks like you're pointing over here, and you see car lights over here, or marker lights on, you can see. And so because of the curve in the road, it did appear that the car was off the road, and that's why he never slowed down. So Joellen was able to explain that from a human factors perspective, why Sergio wasn't negligent, because it would appear that the car was off the side of the road. And we had the big aerial view showing how the road curved. And so she was just brilliant. And no one else picked up on that. And it was effective. And then the other thing she proved was Austin. I asked her the question, well, Austin was in class. Austin had the educational material. It was in his locker. They found it after the accident. And it clearly tells Austin that he shouldn't do a 3-point turn on a highway. Wasn't he negligent for not telling Mr. Meekum, no, that's too dangerous? And she said, well, actually, I've done a lot of study about people's tendency to do what authority figures tell them to do. And she talked about the Nuremberg trials, where the Nazi officers were told to kill people, and they did. They did what they were told because their authorities figures were telling. And then they did experiments after the Nuremberg trials where they had someone in a white trench coat, or a lab coat, I should say, and they would say, okay, on the other side of this room, there's someone with electrodes connected to you, and the electrode shock goes from 0 to 10. Let's start with 0, and you do that, and they'd push the button and shock them, and okay, let's go up to 5. Well, they would do it. They say 10 is near lethal shocking, you're delivering a near lethal shock. Turn it up to 10, and most people would do as they were told because the person telling them to do it was in a controlled experiment with a lab coat on. So she provided that testimony. Her actual testimony didn't take more than 20 minutes. It was extremely short, extremely concise. We argued about whether she could testify for probably an hour and a half. I mean, the defense wanted to keep her off because they didn't want us having the final say and the final explanation of what happened. And she just brought it home. She's an excellent witness. I use her a lot, but she is just very impressive on the witness stand. She's really a smart lady, and her testimony is very subdued and very just matter of fact. And I think that really drove it home. I think that final push pushed us over the edge. That's why it took him an hour. I mean, once Joellen got done testifying, it was done. I mean, I don't think I needed to give a final argument. I really don't, other than to go in and say, I want 5, But the witnesses I had were fantastic, and Joellen was fantastic.
So was the fight over her testimony over whether it was proper rebuttal or whether
Exactly. Yeah, proper rebuttal and whether she had the credentials, and it got upheld on appeal. Read Justice Jim Jones' decision. He wrote an excellent decision, and he goes through the entire case. But there's a lot of good discussion in there about reckless and what you need to prove and why. And then they complained about some of my final argument, which I did screw up on. Said some things I shouldn't have said that wasn't supported by the evidence, and they obviously brought that up, but it was really minor, thank heavens. But it's a good decision, and there are a lot of different topics that they talk about, and one is the rebuttal testimony. The other thing they go into detail about is Joellen's background and credentials. I know a lot of attorneys have been worried about whether Joellen would be qualified to testify, and I know they always try to keep her off, but the Supreme Court, there's a Supreme Court decision now where Joellen's credentials were upheld, and she talked about some interesting issues like transference of authority is what the psychological concept was, and then also just the human factors perspective of what Sergio was seeing and how he was interpreting what he saw. Her testimony was awesome. I don't think I have. Let me see. Yeah, I guess that's all I have. I hope I didn't take up too much time, but I appreciate your time, and